see what else we've got here. For the purpose of the definition of abuse, it's going to be Family Code 6203 to define what that means. So reasonable proof of past acts or abuse. For the purpose of this code provision, Family Code 6203 defines abuse, which is to intentionally or recklessly cause or attempt to cause bodily injury. Sexual assault, to place a person in reasonable apprehension of imminent serious bodily injury, and to engage in behavior that has been or could be enjoined pursuant to Section 6320. Abuse is not limited to the actual infliction of physical injury or assault. So many times I've argued, well, there hasn't been any physical violence between, there have been no threats. I mean, I make some general statements, but they really can look at what's happened in the past in order to grant the temporary restraining order. They're granted quite liberally. If it's not related to domestic violence, it's reasonable proof of harassment, unlawful violence, or credible threat of violence, and great or irreparable harm would result to the petitioner. I would advise everybody to read CCP 527.6. You're going to want to go through 527.8. I did include the California Rules of Court attached to your packet for restraining orders. That's under 5.630. That will go over some of the procedures. And I believe that in 5.630.5, only criminal court can trump dependency court orders. So there is a priority of orders to think about. In our court, if you receive, a lot of times when the petition is filed, we'll receive those DV forms that are issued in other courts. If it's from a criminal court will trump our court. If it's from a civil family law court, we will trump those orders. So just know that this court can make orders. If you have a restraining order that's already been issued, a permanent order from family law, let's say, you have a case come in, you might want to consider filing a new juvenile restraining order so that we can make changes to those orders, since we do trump those orders, so that we're not dealing with a restraining order that's been in effect for, the next year and a half to 2 years. It should be noted that our restraining orders only are in effect for a total of a permanent restraining order for 3 years. There are some guidelines in terms of the temporary. The duration for temporary is 21 days, 25 days of good cause. That's under WIC 213.5C and California Rules of Court 5.630G. We have a sample here, and I apologize. Some of my forms today we're not pulling up. The Judicial Council website was down, and I may have used some of the older forms. I have to double check and see. So I'm trying to provide you guys as much guidance as possible. I'm going to get out a real sample for everybody so that they can know exactly what to put on. But this is a sample that I provided. The request for the restraining order is on top.
Is this why Ms. Cunningham's been out?
Could be. This is with Miss Sherry Cunningham and her child, Sherry Cunningham Jr., against the perpetrator of DV, which is Miss Rachel Ewing. These are pretty simple to fill out, the JV 245. If you have if you have never filled out a restraining order, there is no other restraining order in effect, you would fill out the JV 245 in our juvenile form. This is the request form. If you already have a temporary issued from a different court, you don't necessarily need to fill out a JV 245. It all depends on your clerk. Most clerks will accept the domestic violence restraining order paperwork that has been submitted, and you don't need to fill out this form. Sure.
For the burden of proof for the permanent restraining order.
Right. There's two burden. By the way, I did not go over that part, which is something we need to know. The burden of proof for an order after hearing, if it's related to domestic violence, it's preponderance of the evidence. If it's not related to domestic violence, it's clear and convincing evidence under the Code of Civil Procedure 527.6I and 527.8E. So that is something, there's two burdens here, and it really depends. So I've heard some people say it's a preponderance standard. I've said it's a clear and convincing, and we were both right. So this is how much it's why restraining orders are so confusing, is because there are multiple standards and it hasn't always been clear. I was reviewing this cheat sheet which thankfully Honorable Shauna Schwartz prepared that we found, and from 2008 her paperwork and her cheat sheet is completely different, and it states everywhere that really it's unclear what the burden of proof is, it's unsettled, so things have really changed. I will provide you with some cases that are important. As I'll go over some of the forms, I'm also going to provide you with some information about some of the cases that you may want to think about for restraining orders as well. So yes, the burden of proof, it's either preponderance or clear and convincing, and it just depends on the conduct. Who can be protected is, dependent child, other children in the household, parent, legal guardian, current caregiver, social worker, CASA, and as Dennis pointed out, we are not included in these orders. But our clients really don't do anything wrong too often, so they haven't really, with our clients, it's really difficult for them as we're applying for restraining orders and we're requesting, kick-out orders. I think that we should discuss with our co-counsel at the earliest opportunity if you're making a request. You never want to find out when you're in the midst of a hearing that somebody's requesting a restraining order all of a sudden. You want to make sure you're all on the same page and you know what to expect. Whether you're going to include the children or not, that's also something that is important. In regards to including the children, there's one case I refer you to, which is In Re CQ. It's 219 Cal. 4th 355. And in that court, there was no evidence that showed that a father was a danger to his children. The parents were separated and they were living together, and the father grabbed boxes of glass figurines and threw them on the ground in front of the mother and their 12-year-old daughter. He struck the mother in the arm with a closed fist and left. The family's 3 other daughters did not witness the event. And when the social worker interviewed all the children, they basically denied seeing anything. Even the 12-year-old said, I didn't see anything. And the mother reported that there was more than one incident. There's past incidents of domestic violence. And father even apparently bribed some of the children to not say anything, not to disclose anything, and that somehow came out. And what the Court of Appeal said in this decision was that, the juvenile court erred in listing the children as protected persons, as there's no evidence indicating the children's safety might be in jeopardy.
What's that side again?
That is In Re CQ. It's a 2013 case, 219 Cal. 4th 355.
Thank you.
So something to think about, whether you're going to include the children or not. We have our request. I'm going to go back to the form. You, again, don't need to always fill out that request form. It just depends on what your clerk wants. But if you have another restraining order that's in effect and it's a temporary order, you can fill out that notification form that I showed you earlier, notifying the court that there's a hearing here. You can fill out the paperwork and issue a new juvenile temporary restraining order. On our paperwork, you can all stipulate to extend time to go beyond the 21 or 25 days so that you can hold the hearing simultaneously with the jurisdiction hearing. I like to do that because I don't want to hold 2 trials. I want to make sure my client has some time to cool off, and by the time we get to juris anyways, most of the time they've already decided what the relationship status is going to be. Sometimes they're back together by then. That could change everything. So I think that it's beneficial sometimes to handle everything at one time. We have a notice of hearing and temporary restraining order, JV 250. It's just a sample of what you need to check. This restraining order will be rejected. There are specific boxes that you must check. For instance, 7E is one of them. So you need to make sure you check all of the appropriate boxes and you review this. And you want to try to serve the temporary order if the parent was not present. Everyone has access to CalServe. You can use that. You might not want to use your investigator to serve a restraining order. If there's somebody who's violent, you want to take that into consideration. So you want to try to do your best to serve them and give them as much time as possible. 5 days sometimes might not be really realistic. 5 days before the hearing, you can try. If you cannot serve the person in time, you can request to reissue this restraining order, and that should be on your next form, which is JV 251. And sometimes you might want to stipulate to extend time. So sometimes a temporary order is set. This is just one sample. If you cannot serve the parent, then you'll check for A. You'll receive additional time. The court will set another hearing. And on your cheat sheet, you can determine how many days it should be reissued for, and when it's going to be in effect for. That's under WIC 213.5C and California Rules of Court, again, 5.630G. And 213.5C, and that's under duration. So if you need some guidelines in terms of what to look for, what the authority is, it's all here on the sheet for you. So you can reissue the restraining order. You've got the order after hearing. Hopefully most of you have filled those out. And I think that what is most helpful would be the last forms here after the restraining order. The change to restraining order after hearing. You can change or modify the restraining order. You can terminate the restraining order on this form. So again, if you have a restraining order, it might be most helpful if you have a permanent order issued from a family law court. You might want to consider making the request to apply for a restraining order on our juvenile court form so we can make modifications. Our court will trump those other courts. A lot of times our clients are advised they must file for a restraining order here in our court, not go to other courts. You want to make sure that we do that. You want to make sure the other courts are aware. Our courts are actually required to consult with the criminal court and some of the other court systems. There is a local rule. Let me get that for you guys. Let's see. My apologies, I had it earlier. I believe it's 8.34. Court communication protocol, those are in the local rules. So it sets forth that there is a communication protocol for domestic violence and child custody orders. We're supposed to avoid the issuance of conflicting orders. So under the local rules, the court is required also to do a background check on the clients, determine if they're on probation or parole. I did not know that, so that's something that you should be aware of. The court should be communicating with the other courts. So consider whether you're going to file a juvenile restraining order if you have one issued in a different court, especially if you have a no contact order. You want to make those modifications. If there's an emergency situation, you can always advise your client to go to the nearest sheriff's office and consider filing an EPO. Emergency protective order can be issued and requested by law enforcement. They're only in effect for enough time so that your client can apply for a restraining order in our court. Sometimes on a weekend something happens, you want to make sure your client, they can't reach you. You're obviously not going to be filing a restraining order when on Monday morning unless you're here in the office, which some of you might be. But you just want to be aware that restraining orders do have an impact as well on custody orders. You can modify them, you can quash them, they can go up to 3 years, but you don't have to issue them for 3 years. You can issue them for 6 months, for a year, whatever, you could always request for the order not to be issued for the full time period. That pretty much sums up most of these forms. There are additional forms involving waiver of reunification services. Every firm is a little bit different. I prefer that my client appear in court and have the waiver, make sure that's an intelligent waiver when you're dealing with something as important as waiver of reunification services. I like them to think about it. I've never waived reunification services at the first hearing. I just do not do that. I want to make sure they have enough time to think about it before we actually execute that waiver on the record. There's information, for instance, there's a caregiver information form. There are forms involving de facto parents. We do represent de facto parents right now, and so you can present information on the caregiver information sheet. And I have not included it in dependency forms because we just so rarely do that, but just know those forms exist. We have forms regarding psychotropic medication. Those are JB 200s, JB 220, JB 222, and you can file an opposition to any application for psychotropic medication. So if your client calls you and says that they received notification, somebody's applying for, requesting that their child be medicated, they're not in agreement, you can fill out that form and file it with the court. Let's see here. We have a proof of service form, JB 510. We have notice of intent to file a writ petition. Do not forget about that, JB 840. Let me see. We've got notification of mailing address. So that's pretty much sums up some of the most important forms that we have. I would also like to inform everybody that these forms are available in many different languages. We do have a general information sheets to provide our clients with. So if you're going over a case with a Spanish language interpreter and you want to provide your client with guidance in terms of what these forms are that you're going over, many of the forms are available in Spanish, Korean, Vietnamese. We should, use these forms, hand out brochures. I don't know why we don't use them more often, but we have a waiver of rights form in Spanish we can use so that they really can see what they're going over. Information forms. Also, there's findings, the 21E, 21F, 22, all those findings the court needs to make, those are all on the Judicial Council website. So, that pretty much concludes this training on forms. I will let everybody know that we need a training on juvenile custody forms, and I just do not think we can handle, that would need its own training in and of itself. There's a lot of things that are really unsettled, and we have discussed with Judge Pellman, and she is conferring with a family law judge so that we can have a complete training on all of the family law that goes into decisions when they receive our juvenile custody orders, things that they will be considering regarding change of custody, whether someone can move out of state. And then Judge Pellman will give her input into our juvenile custody orders. As a family law judge, she's seen a lot of issues with some of these juvenile custody orders that we filed and how that they're not as specific as we would, she would like them to be.
The mediator now, I've sent one case recently because he came down to our court, I think, looking for business, maybe he was walking around. He's really pretty good. I mean, what it is an adult type of exit order rather than the ones that we fill out, 1 or 2 little sentences. So if you have the right type of case, you can make an appointment and he will type it up. It looks like one if you were in family law with a real family law attorney. It looks like that, and it's fair to everybody around. So if you get to that point, just ask for the continuance, pick the date, let the judge know, and then
we do have, all the forms are available, and I would like everybody to email their directors, and if you have any specific weird issues that are happening in your court, questions about, we've had some issues right now with custody orders that have been filed incorrectly, with dates, names, all of the information incorrect, and the case was JT'd and it hasn't been, the clerk's office hasn't handed it back to us, so just make sure the information is correct. Make sure you double check for those custody orders. And if you have any questions about them, email your director, your supervisors, and we'll collect all of that information and we'll hopefully be able to answer all your questions, whoever does that next training. We'll see. All right, any questions today?
Can you know something once at JT's?
That's a good question. I asked today, I wanted to know if we could. I think that you, we'll get an answer for you. That's in the next training, not today. Any questions about forms? All right.
you can check it.
Continue. Thank you. All right.
This is the first getting her. That's a different building with a new direct.